afternoon. How you doing?
I'm well, thank you.
And welcome back to Law for You. And today we have attorney Terry Dennings. Now, Terry, tell us a little bit about yourself to give our viewers some background on your experience educationally and socially in becoming a lawyer.
Okay, I graduated from Wayne State Law School in 2005. And since that time, I've been practicing primarily in litigation with a focus in labor and employment. So from the employment perspective, I've represented employees and employers. I've worked at small law firms and large law firms, including the 10th largest law firm in Michigan. From the labor standpoint, I've represented labor unions and also represented management in negotiating labor contracts. So I have, experienced the full scope of employment issues.
Well, you look real young.
Thank you.
Okay, that's a compliment, okay? I don't get that compliment that much no more, okay? I'm always somebody's auntie or grandma. But anyway, that's okay. I'm in the land of the living, so I'm not mad about it. One of the things that I'm so interested in, Terry is, she's just, she's very well spoken and, but she is a piranha. Let me just say this to you. But one of the things that, we had discussed, and Terry and Delden Law Firm, which she works, has been very, very instrumental with me in being able to assist in areas of discrimination. This is a new area, and a lot of people just don't know what their rights are, what the law is, and what can be done. So one of the things when I decided to do the Law for You, it really was to enlighten people about the process of discrimination and what it means. Historically, we think of discrimination in terms of what occurred during the 60s, separate but equal, and Dr. Martin Luther King equalizing things for blacks so that it was no longer any separate but equal. I mean, it was, but it was all equal. So now, that's not really what this area is talking about anymore, is it? It's not really just talking about, me using the black bathroom opposed to the white bathroom. But in fact, it's a little bit more centered on employment issues in that particular area. And so today, let's talk a little bit about that. Let's talk about the application process. I go to apply for a job. I don't have a job. Can my rights be violated during that application process by prospective employers if they ask certain questions that they're not supposed to?
Yes, during the interview process, there are certain areas that the interviewer or company is not supposed to ask you about.
Could you give us some examples?
Are you pregnant? Are you planning on having children?
Wait a minute, hold on for a minute. So you're saying, I'm a lawyer, not now, I'm just saying hypothetically, I'm a young lawyer, and there is a opportunity for me to have a job. And, I come in and I'm relatively young. So it's wrong for them to say, well, we got this big job for you, but we don't want you to go out here getting pregnant right off the bat, okay? Because if so, we're going to pass over you and we're going to go to the other applicant. That is illegal just in an application process.
Well, I don't want to say illegal per se, but
actionable.
What I will say is that employers are advised not to ask those questions, because if they decide not to hire that person, then that person has an argument that, well, they didn't hire me because I'm pregnant, and they know that I'm pregnant because they asked me in the interview.
Okay. And when you say that they have an argument, you're talking about in the court?
Yes.
Okay. So my question then becomes, if someone were to ask me that and I'm going to get a job and they said, you're down to the final applicant and we've got maybe another applicant, and we just want to know, what's your long-term goal? You're relatively young. You just got married. Do you plan on starting a family? Because we've got a big contract and we're going to be working on it night and day. And if you're going to be having a family, that may preclude you from being a part of this big contract negotiation. That's wrong?
Yes, that's wrong. You're not supposed to consider certain factors in making employment decisions.
Okay.
So hiring is within the realm of an employment decision, and so if an employer is considering your marital status or your familial status in its decision on whether or not to hire you, that is illegal.
Okay. And so basically that's surprising because I don't even have a job. But you're saying that as an individual that I have certain rights even before I'm hired that can't be infringed upon by a prospective employer.
Yes, in the hiring process.
Okay, very good. What is at-will employment? Does that mean I'm a step above a slave? That mean I don't have no rights?
At-will employment means that you can be terminated for any reason or no reason. And you can likewise quit your job whenever you want for any reason or no reason. I get calls, from people who say, I was fired because I was late, or I was fired because, I got into an argument with my coworker. Well, if you're at will, then your employer can fire you for those reasons. The only exceptions are that your employer cannot consider certain factors in deciding to terminate you, like your race, your age, your gender. But other than that, your employment's at will.
Okay, very good. And you talked about a couple things that we need to talk about. You said that there are factors that cannot be considered. Let's talk about those factors a little bit. What are they?
Okay, there are, I may miss some, but we have race,
gender,
age.
Now, is there a presumption in the law that there's a certain group or certain age in which it's more prone to occur after 40?
Yes, 40 and over.
40 and over.
Age, color, national origin.
All right, ethnicity.
That would probably be national origin.
What about
Genetics.
Okay, and give me an example of genetics.
Oh, wow. It's unlikely most of the time that an employer would have your genetic information, but if your employer somehow had your genetic information, which would indicate that you may be prone to a certain kind of disease or illness.
Okay, what about this? What about if I'm gay and I'm considering becoming transgender? Would that be a form of a genetic or no?
No.
Okay, what would that fall?
Well, not to my knowledge.
Okay, what that one? Okay,
I haven't specifically.
Okay, well, let me ask this question. What about religion?
Yes, religion is a protected category.
Okay, so when you say they're protected, what does that mean? I don't.
That means that the employer cannot consider those things. They're protected categories. They're categories that the law protects you from in terms of your employer making decisions. So I'm protected, my race is protected, my religion is protected, my gender is protected. Those are factors that my employer cannot use when making decisions relative to my employment.
So let me ask this question. I'm a black female and I have a status, there's a status quo that we have to reach. We have to have 50 sales a week. And there is a white counterpart who is a male. And I have 49. I get fired. He has 42 and he still has a job. Is that something that is illegal or is that okay?
Well, I couldn't say just based on those facts. In order to prove discrimination, you have to show that there is a similarly situated individual who would be the white counterpart, same job, same everything, who engaged in the same conduct and was treated differently.
So if that situation, if he got to keep his job and he only sold 45 cars, but the quota was 50 and I sold 49 and I lost my job, I could make an argument that he was treated differently than I was.
Yes, if they say that the reason why you were terminated was because you failed to meet your quota. Now, if they say you were terminated because you have a bad attitude, then that's a different consideration.
Okay, what is an employee who believes she or he is being discriminated? What can they do? do they have to suffer in silence?
No, they don't have to suffer in silence. One thing that I recommend to employees who call and are having difficulties at their job,
And when you say call, where do they call?
call me at Delden Law, 313-771-5600.
Now let me tell you something. She a young girl because she talks so fast. I'm going to say it. 313-771-5600. 5600, go ahead.
I forgot the question.
Okay, can an employee do if they feel that they're being discriminated against?
Okay, so employees who call me who are in positions where they feel like they're having issues or concerns with their job, one thing that I tell them to do is to take notes. And I do that because if there is an issue that proceeds, they have a timeline and they have evidence of what they say occurred.
So wait a minute, hold on for a minute. You're saying that somebody's notes can be evidence?
Yes.
Okay, so they don't need to have a video?
No.
They don't need to have pictures?
No.
It's good enough if they keep detailed records about what's happening to them. Is that correct?
I mean, it would be better if they had video, etc. But contemporaneous notes, which are in the legal realm, notes that are taken at the same time or around the same time frame as the incident, are admissible as evidence at trial.
Right. So if I feel that my employer is discriminating against me, I don't have to wire myself up and say, speaking to the mic, okay? What'd you say again? I don't have to do that, do I?
No.
Okay.
You can note whatever occurred, and you can also note witnesses or people who were there, so that if it's 6 months down the line or a year down the line and you're trying to talk about this incident and you're being asked or questioned, your credibility is being questioned, you can say, well, these were the witnesses, these were the people that were there, this was the date, this is what happened, and these are the witnesses.
So say for instance, I'm in a work situation and there's another employee, and this person always has something disparaging to say, some little racial jokes or sexual jokes or something like that, and boy, I'm getting sick of it, and I indicate to my employer, I really don't like being around Bob, because every time I'm around him, he always has something sexy to say or something racial, and it really makes me feel uncomfortable. And all of a sudden I look up and I find myself, my job, my hours are changed. I've been sent to the night shift opposed to the day shift. Can an employer retaliate for reporting suspected discrimination? Is that legal?
No, that's illegal. Your employer is not supposed to retaliate against you, change your working conditions, change the terms of your employment because you've reported a suspected violation of law.
Okay. And what should you do when that does happen? Should you go to your employer? Should you go to your boss and say, listen, I'm not really comfortable, or do you just write your notes? How do you go about that?
Well, you would write your notes, and then you would also, one thing that people should do is check the employer's handbook.
Okay.
Because the employer's handbook, depending on the sophistication of the employer, may have a complaint procedure in there, or a complaint procedure or a department that you are to submit your complaints to.
Okay.
So you would make your complaint to your supervisor, definitely. You would need to report. If it is your supervisor that's causing you the issue, you may need to make your report to Human Resources. I think Human Resources is more of an independent, for what it's worth, more of an independent department. And so you may be better off taking your complaint directly to Human Resources as opposed to your direct supervisor.
Terry, look, hey, I'm over 40 years old. I'm a single mom. I need my job. I know what they're doing at my job is not right. I don't want to lose my job. I can't lose my job. The last time, somebody talked about Bob, they took him from the day shift to the night shift. Then I looked up, they didn't work there anymore. Mm-hmm. I don't want to lose my job, but I don't want to continue to work in an environment that is, I mean, I don't feel good about it. You know, every time I come to work, I feel like, oh my goodness, I get a knot in my stomach. I don't want to be here. You know, it's just so negative. It's just so hard to be around. What do you tell an employee that's suffering like that?
And those are very difficult phone calls to take, and they're difficult discussions to have, because I sympathize with the individual that's in that situation. But you can't have it both ways. You can't be silent and expect for something to be done. So, you know, on a certain level, you know, the employee has to decide what risks they're willing to take. And again, it would be illegal for them to be terminated because they make a complaint, but that doesn't mean that it doesn't happen.
Okay.
And it doesn't mean that it won't happen. So part of that is, you know, to make your complaint, maybe start looking for another job elsewhere.
Okay.
Or maybe start looking for an opportunity to transfer to a different department so that you can still maintain your employment and pursue whatever issue it is that you have with the company outside of the department that they're currently in. But that is definitely a consideration, and you try to encourage people to, you know, utilize the law, but you can't guarantee any protections. You can't guarantee that an employer isn't going to violate the law.
Okay, what are governmental agencies that people can go to if they find, you know what, I went to Human Resources, they didn't do anything. I went to my boss, they didn't. What governmental agency can I go to that would be able to assist me in this discrimination that I'm suffering with?
Well, the two primary agencies for employment-related discrimination are the Equal Employment Opportunity Commission, which is
EEOC.
the EEOC, and they have a website, eeoc.gov. It's very informative. It has information about what we've discussed, the protected categories, how to file a complaint, what that procedure is like. Then in the state of Michigan, we have the Michigan Department of Civil Rights, who they take discrimination complaints for in a variety of different contexts, but employment is also one of them. Those charges are free. It doesn't cost the employee anything to file the charge. If there is this is getting a little bit more specific, but if it is a specific issue relating to pay, for example, or medical leaves, there are other governmental agencies that cover those areas, and just like the EEOC, an employee could file a charge with those agencies as well.
Okay, so I go to the EEOC, and how does it work?
Well, you go to the EEOC, or you fill out the complaint online,
Okay.
and then I know just generally, I know sometimes they have the person come in, sometimes they just go based off phone communications, but you file your charge with the EEOC. The EEOC sends a copy of your charge to your employer, and then your employer has the ability to decide if they want to mediate through the EEOC, because the EEOC has a mediation process. So that's
Okay.
where both sides come in with the EEOC's mediator, see if they can resolve the issues. If not, the employer will provide a response to the employee's charge. So the employee claims, you know, I was terminated because of my race, and, you know, Bob did the same thing and he was not terminated. The employer will provide a position statement and a response to any request for information that the EEOC asks for relative to that employee's termination. And the EEOC investigator will investigate and make a determination whether or not the EEOC believes that discrimination occurred.
Okay, well, what about, can I file a complaint with the EEOC if I don't want to leave my job? Can I do that just to let the EEOC know what's going on?
Yes, most of the time the employee is probably still working when they file their charge with the EEOC.
Okay, very good. So I don't have to be terminated.
No.
Okay.
That was just an example I used. No, you don't have to be terminated. Maybe you're still there and you're demoted. Maybe you're still there and you've been suspended. Maybe you applied for a promotion and you didn't get the promotion. Somebody else got the promotion.
Terry, please tell the viewers, and this is something, I've undergone a lot of discrimination, harassment, bullying. I can't take it anymore. I've done what you said. I've gone to my employer. I've gone to Human Resources. Nothing happens. Should I quit my job, or should I do what you're saying and call a lawyer, because maybe I can make them be held accountable? But what happens when I just say, forget it, I quit? What happens to my client?
Well, that is very fact specific. There is a type of employment claim for that situation, and it's called constructive discharge. And that's when an employee feels like they can no longer take it, and so they quit. You can file a lawsuit in that situation, but you have to. The standard for constructive discharge is that the situation was so intolerable that no reasonable person should be expected to endure that.
So would you recommend to the people that are watching, if they're, being on your head or, challenging you and bullying you, etc., and you can deal with it, to call a lawyer because maybe you have a better standing at that point to bring a lawsuit?
I would say yes, to consult with an attorney. It may be that the situation can be rectified through communications and with the attorney and the employer. I've had that before where, an employee was working and they felt like the environment was hostile.
Yes.
And it didn't merit at that time filing a lawsuit, but I did write and communicate with the employer that this was what my client was alleging was occurring in the work environment. And so they took steps to remedy that, and things moved on.
How much time do I have to file a charge with the EEOC?
The EEOC, you have, I believe, 300 days from the date of the incident that you're claiming was discriminatory.
Now, it's 300 days.
Yes.
They do an investigation.
Yes.
EEOC. They discharge it. They give me a right to letter, a right to sue. How long do I have from the date I get that letter to file a claim?
90 days.
90 days. What does it mean when I get a letter that says I have a right to sue? Does it mean I'm going to go be victorious and that, that means that all I have to do is file a lawsuit and I'm going to win? What does that mean?
Well, a notice of right to sue is basically the federal court's way of managing the number of cases that are filed in federal court. And so in order to file a lawsuit in federal court under some of these employment statutes, you have to first go to the EEOC. So I guess the courts probably figure by the time the EEOC has investigated and the person gets this information, they'll have enough information to decide whether or not they should continue and try to file a lawsuit in federal court.
What is a lawsuit?
A lawsuit is the process that a lot of people see on television shows where it begins with a complaint. A complaint is what the person is alleging or what they were alleging was done to them that was wrong. The defendant or the party responding is the one defending the lawsuit and defending the claims that the plaintiff or the person filing the claims is making.
How much time? How long does it take from the time I file a lawsuit to the end? How long does it normally take?
Wow, I would say at least a year and a half.
Wow. Okay, wait a minute. How much does it cost?
It will be varying costs, but just to file a complaint, I believe it's $375. So
Okay.
that's just to file the paperwork to get the lawsuit started.
So if I'm, being discriminated at my job, and as I said, I went to my employer. He's not doing anything. I went to Human Resources. I decided to go to EEOC. They give me a letter, a right to sue letter. I come to you. Will you charge me, or how does that work? How do I get to court and be properly represented? Do you pay hourly? Do you pay at the end? How is the money determined to get a lawyer?
Well, all lawyers have the ability to decide how they want to handle cases. For us, we consider the client's ability to pay. And typically in employment cases, if the person is without a job or without sufficient pay to pay hourly, and that would be extremely expensive to pay hourly. So we will get a retainer from the client to cover some of the costs, the early costs, so that the client is invested in the case, if the client has the means to do that. If not, then we work out other arrangements where we can assist with the costs up front and then recoup that at the end if we're successful.
Now, there's some forms of discrimination where you can get attorney fees. Is that correct?
That's correct.
Okay. And so would that be able to help offset my costs from that perspective if we decided to go against a claim that we were able to get attorney fees, or no?
Well, attorney's fees are typically at the discretion of the court and
Okay.
the amount of attorney's fees, so that's never a guarantee. And I mean, attorney's fees wouldn't come into play until the very end. And by the very end, I mean once the case has gone through trial and there has been a successful verdict for the employee on a particular.
I
claim.
I got a right to sue letter. Am I going to get $1 million?
Probably not.
Okay. What goes into determining the amount of an award that I'm going to receive? What types of things? Obviously, we're talking about the type, okay? So it depends if it's racial discrimination, if it's age, if it's gender, sexual. We got that. But what other things go into building up $1 million verdict that maybe I need to be aware of now? So like you said, when I take my notes, if there's something that, I overlook, that's no big deal. Or, Bob always likes to say things that are, sexy to me, but that's okay. He's a nice guy. He's a family guy. What are the things that I need to look at in terms of writing down or informing my lawyer that may be able to help me get $1 million? Do you understand my question a little?
I do understand your question, and it's a difficult one to answer because employment cases are fact specific, and so when you're evaluating or looking at an employment case, especially if you're a jury, you're looking at the totality of the circumstances. You're looking at everything that has occurred to that person.
So let me ask this question. Hey, Bob, he gets on my nerves and everything, but, I don't care, that when, Bob, says something, like, oh my, your legs are looking good, or, I like the way that those jeans are fitting. Should I include that and tell you? I know he really doesn't mean anything by that, but will that help me later on if I find that he is, retaliating or making it hard for me? Are those things that I need to let my lawyer know?
I would say be over-inclusive in what you tell your lawyer rather than under-inclusive, because sometimes...
So basically, let me explain this to you all. She said under and over-inclusive. Let me explain this. Let me break it down like I used to have to do with the juries. It's better to have it and not need it than to need it and not have it. Did I say that? It's better to have it and not need it than to need it and not have it. So basically what you're saying is that if it's something that you know is wrong, you need to write down everything that goes on, almost as if it's a diary. Keep it abreast so that you can notify your employer. If they don't do anything, don't let anything slide. The fact that Bob might be a nice Christian man and he just liked the way that my jeans fit, you better write that down if you're trying to get a lawsuit. Because when you engage in a lawsuit, that's almost a mini battle. That now I'm going against my employer. Mm-hmm. And they'll know things about me too. Right. So I need to be able to say things about them that I know is going on. Is that correct?
That's correct.
Okay.
And also in the circumstance you just mentioned, if Bob is saying those things and you're ha-ha with Bob, then that's not going to reflect well on you.
Right.
One of the standards for sexual harassment in particular is that the comments are unwelcome. And so if you're giving the person an indication that you enjoy what they're saying to you, then you may have some issues later on down the line.
Okay, well, let me ask this question since we're here now talking about it. I work, say for instance, and you get a boss, and some of us have unfortunately have encountered this, who seemingly every time I turn around, they're there. They're looking at me. I catch them staring at me. They got these goo-goo eyes. And I just feel extremely uncomfortable, okay? And basically, all of a sudden, it feels like this person is invading my space And they are in a position to make my job easier by not making me work so many hours or giving me a promotion. I'm there to do my job. I don't want anybody to give me anything. But I know that this person can make it difficult and challenging for me. And then they decide maybe to say something, an innuendo or something like that. And, I say, I'm really not interested in that, but they keep pursuing me. Is that a claim of sexual harassment if they just keep trying to tell you they're interested in you, or, even something, we are adults. They may, say for instance, get a phone number. And there was a case where a gentleman, unfortunately, was sending genitalia pictures, okay, of himself to this woman who was was a subordinate, and it was unwelcomed. What do I do? Do I just tolerate this because I need my job? What do I do about that? I mean, should anybody have to endure that?
No, nobody should have to endure that, and that's the point of the employment laws, to prohibit that and to stop that type of conduct occurring in the workplace. But an employer can't fix something that they don't know about, and so in that situation, yes, the employee should report that.
Okay, definitely. And definitely if somebody is sending them texts or some type of pictures, should they retain that information or just say, oh, I can't look at that? Should they delete it or what? I mean, what do you think?
Well, they can, no, I'm just kidding. They should retain it, yes.
Okay, very good. And
it would be evidence.
It's evidence.
It's evidence.
Okay. Now, when those type of cases, say someone is, sending me inappropriate text messages, inappropriate pictures, and I ask them, I say, well, you know what? I'm dating, please stop. And they continue to do that. Do I have an obligation at that point to go to my employer and tell, or what do I do? I mean, I don't know what to do. He's my boss. I mean, I don't know what to do. What do I do? I'm asking you.
I mean,
should I report it if I'm uncomfortable with that?
Yes, you should definitely report it. And when you tell him to stop, I would do it however he's sending the pictures or she's sending the pictures. So if it's by text, then I would, please, I do not want to receive these from you, these pictures. Please stop sending them. Because you can tell the person verbally, but again, as an attorney, I'm always thinking down the line. So when it comes to the question of, did you tell her to stop or did you tell him to stop? And the employee says, yes, I told him. Well, at that point, it's, the employee's word against the other employee's word. But if you have it in writing, then you can say, yes, I sent this text on this date and told him not to send me any more text messages.
Now let's talk about that. Sexual harassment is a little bit different, okay? Yeah. In that there is a stricter liability. The courts are saying we're not tolerating that because nobody should have to work and have sex, okay? Now that's slavery. That's just way too much. I don't care what job you have. That's just a little bit too much. So my point being to you is that the courts look at that a little harder. When I say strict, that means that do I have to show I was emotionally hurt, or can I just show, hey, this guy's sending me these pictures, I told him to stop? Or do I have to show that it is emotional damage to recover?
No, you don't have to show that it's emotional damage to recover, because it would be a violation of the law in and of itself, the sexual harassment. Now, the value of, the amount that maybe you're able to recover or that your employer will give you for the harassment will be probably increased if you can show that what was being done to you impacted you in some way.
Okay, so that's the situation. So basically, it's my understanding, if somebody sends me an inappropriate text, like, I like how that black dress was fitting you today, then I shouldn't maybe just run it straight to my employer and say, or I should let them know. But I shouldn't go out and file a lawsuit.
No, I don't know that an attorney would necessarily file a lawsuit for you based off that one instance. But
what if it is a pattern? And they will not, but they do it in a friendly way. I really liked how that dress looked on you. You know, it really makes your breasts look good, but something that's a little not as overt as sending a picture of the genitalia, but something that just makes me uncomfortable. Does that still count as sexual harassment if it's talking about a part of my body, or, you know, something about me in that way? What constitutes it?
I mean, the courts will look at the specific conduct or language in the context in which it occurred, and so I can't say, you know, in every situation this is going to be, you know, actionable or considered harassment. The standard is typically severe and pervasive, so that means it has to be more than one time. It has to be, you know, a continuing pattern. You've told the employer, you've given the employer an opportunity to investigate and take action.
But this is their star employee. You know, this person, you know, sells the most cars, and they're not going to mess with him. Oh, that's Bob. Don't worry about it. Listen, if you weren't sexy, Bob wouldn't say it to you. You know, that's okay. But I don't feel good about that. You know, and I want to be a team player, but I don't feel good about that. If I, in fact, obviously, if you feel that you are being harassed, you should definitely reach out. But should you get some type of maybe counseling to see if you can help to stay in that particular job, to maybe strengthen you to be able to emotionally to fight back? I mean, what do you think about that? I mean, you know, when you have people that come in and they just say, you know, I can't give up my job, I don't want to tell on Bob. Do you think that they should go to counseling, or should they get counseling before they come to you?
I've never thought about that question. I guess if a person is in a situation and they feel that they need some assistance in coping with the situation that they're in, be it a work environment or a coworker or relationships, I think that it's a good deal to consult with someone who's a professional who can help the person kind of figure out where they want to go and what they need to do, because maybe the person that's counseling them will, you know, encourage them and let them know that they are strong enough to, you know, to report, and that everything is not going to be, you know, as awful as the employee may be thinking in their mind.
Because here's the situation. Jobs are hard to come by. If I'm over 40, you know, then you start to feel like, I got to take this. I got a family to feed. You know, I can't just up and give my 20 years that I've been working here at this plant. I can't just give it away. I'm sorry. I just have to take it. But maybe if I get counseling, and maybe somebody can make me believe that I'm strong enough to stand up for myself. Is that what you mean? And in that way, so that I'm not dealing with this. I mean, I've heard people, I had a woman, oh my goodness, it was heartbreaking. She was in tears. She said, I cannot take. They're bullying me. They're calling me. They're talking about me being overweight. They're talking about me being old. This woman, I thought, was about to have a heart attack on the phone. I said, ma'am, before you even call me, you need to get your mind right, because I knew I was afraid for her myself. You know, she said, I can't take this anymore. I was able to finally calm her down and just encourage her. Listen, you need some professional help. And it's not that you're crazy or something's wrong with you. It's just that when there is a pervasive type of bullying, mistreatment at your job, then there's times that you need to seek treatment. Would you agree?
I would agree.
Okay.
And most of the time, I mean, I'm not going to say most of the time, but in situations like that, I think more often than not, the resolution is for the employee to probably try to find work someplace else. And that's because it is highly unlikely that an employer's, you know, culture is going to completely change overnight.
Let's talk about religious discrimination. I happen to be Muslim, and there's certain holidays that I want to celebrate, and there's certain things that I have to do, or I'm Christian, or I'm Jewish. What does my employer have to give me accommodations?
Oh, I have not looked at religious accommodation in a while. However, you would make the request for the accommodation just like if someone's disabled and they need accommodations to do their job. You would make the specific religious accommodation request to your employer. And then your employer is obligated to investigate whether they can accommodate you. And if it doesn't create an undue burden or hardship, then they should provide the accommodations. Now, there are a lot of things about religious discrimination. It's not quite as black and white as some of the other areas are. There are a lot of gray areas with religious accommodations. But overall, generally speaking, that's how it
But
works.
basically speaking, okay, say for instance, hey, I want to be with my family. I'm Christian, okay? Or I'm Muslim and it's during Ramadan, or or it's doing Yom Kippur if I'm Jewish. So my point being to you, I save all my time. I tell what my religious, oh, you ain't taking off of that. And there are people that can do my job. Could I bring an action in that situation? I told you in advance, this is a holiday that I celebrate. I have time. I don't take any time off. I just want to be with my family. Could there be a possible claim for that?
Possibly. However, it wouldn't, when you're talking about litigation, it wouldn't necessarily merit the cost and time of filing a lawsuit to deal with a specific accommodation issue. So that's something that I would specifically refer the individual to the EEOC for, because that sounds like something that could be investigated and worked out through mediation for free.
Okay, intentional discrimination, telling racial jokes. Is that actionable?
Things are actionable if it's one joke one time. No,
But if it's just a series, like, oh boy, here comes Bob with some more racist, sexist jokes about, oh my goodness, here he comes. Is that actionable?
It could be. There's a claim of hostile environment based on race. So that's when people continue to reference race or use race in a derogatory way, refer to your race, and make your work environment hostile because of your race. So if someone is continually telling racial jokes that are derogatory, could that be actionable? It could be actionable.
Okay, very good. Hostile work environment. You said it. What's necessary for me if my boss gives Amy she gets the light jobs, I get the hard jobs. He always is nice to Amy, he's not nice to me. Does that make a hostile work environment, and can I sue? Amy's black. I'm black. Is that hostile?
Oh wait, Amy, you're the same race as Amy?
Yes.
Okay. So
what do you need for hostile work environment? I tell people all the time, what are the ingredients that you need for hostile work environment? What did you say before they were? Race, gender, sex, age. You have to have that first. That's your cake.
Yes.
And the hostile work environment is the frosting that goes on the cake. You can't have, if you don't have a violation of race, sex, origin, age, you can't have hostile work environment. Is that correct?
That's correct. The hostile work environment has to be based on a protected category.
And those are?
Race, religion, gender, age, disability. You mentioned disability. And under state law, it could be weight, marital status.
Okay, very good. Last, we're going to, listen, do you know we only got like 6 minutes left? It's so fast. That's great. Discrimination in making and enforcing contracts based on race. My understanding, you can get damages, back pay, compensatory damages, punitive damages for emotional distress, humiliation, pain, and suffering, and even attorney fees. So if an employment contract is somehow based upon race, then there's a way that I can get damages if that employer treats someone else in a situation better than I. Like, say for instance, part of the contract is that you have to be a male and you got to be white to do this particular job. That's per se unenforceable. Is that correct?
I don't know.
Okay.
I don't know if that would be per se unenforceable. The thing about employment law is that it's broad. There's a lot of statutes. There's a lot of provisions that apply in this instance but not in that instance. And so really for every single client that I take, I have to research where, these claims are going to be filed, the types of claims, and what the specific damages that the individual will be allowed to get under those particular circumstances.
Okay, and what number is that we call?
313-771-5600.
Okay, quid pro quo. You want that job, then you're going to have sex with me or go out on a date with me. And that's the only way you're going to get a young lady. Is that illegal?
That's illegal.
Does it happen?
It happens.
Listen, I got kids I got to feed. I got 2 grandkids I didn't think I was going to be having to raise. My boss is on my head. He basically tells me, listen, I want you to be my plant wife. And I don't want to be that. But I need this job. And I feel that I don't have a choice. Mm-hmm. Can I sue for that? Do I have to be in a protected class? What about if we both black? Do I just say that's nothing?
Quid pro quo is a form of harassment under the sexual.
So it doesn't make a difference if we're the same race?
No, that doesn't make doesn't make a difference. And quid pro quo only applies to sexual harassment. That is, I'm going to give you something in exchange. I'm in a position to offer or give you something as your boss or as your higher up, and I'm going to do that for you, but you need to do something for me sexually first before.
I've got to be off for my children to pick them up, but I work mornings, days, and it's conflicting. I go to my immediate supervisor. Yeah, if you go out on a date or you have sex with me, I'll give you that. Would that be an example of something like that?
That would be an example. But
okay.
Again, I just want to clarify that things happen, but that doesn't necessarily mean that the employee should believe that they can go out and file a lawsuit because one particular thing occurred.
But if it's ongoing.
If
that's just the norm. You want to get on afternoons, you want to work an easy job, you got to go have sex with Ray. That's just how it is. That's what we do here. That's wrong?
That's wrong.
And it's actionable.
It could be actionable.
Listen, does the owner of the plant need to know about it? If he's my boss, is it enough that the management doesn't have to know or reason to know if this is my immediate supervisor mm-hmm. and he's doing that? Can they allege, well, hey, you know what? We didn't even know what was going on. Can I still sue him because he's trying to do this?
In a quid pro quo, an exchange for an exchange type of situation, the company does not have to know about that to be held liable, and that's why there are the more sophisticated companies try to put in policies and rules that prevent supervisors from dating subordinates.
Okay, so what do I need if I'm going to bring a sexual harassment case and I'm coming to you? What would you think would be things that I need to bring you? Obviously, text messages, would that help?
Yes.
Pictures.
Yes.
Letters.
Anything that the employee has to substantiate what they're saying has occurred.
Is there a time frame? Do I have 2 weeks, a week, a month? You said something about them 300 days. I don't know how that plays into it.
Sexual harassment, it wouldn't be from the first date of the harassment. It could, the point of the 300 days could begin at a number of points during a sexual harassment case. It would just depend on the facts of that specific case.
Retaliation. Can my employer retaliate against me by firing me if I'm exposing discrimination at my job?
They can. They're not supposed to.
Is it actionable?
It's actionable.
And so if I tell the boss, hey, I don't like the way that Ed is, looking at me and Googling me and everything, and then he says, you know what, Ed's a lifetime employee, we're going to get rid of you and we're going to keep Ed, or we're going to demote you. Is that actionable?
The way you phrased it, it may or may not be actionable. You have to, when you're making a complaint to your employer, you have to make it clear that you are alleging a violation of law. If you're just saying that you don't like the way somebody's looking at you, the employer is can construe that any number of ways.
But
and so you need to be clear
Okay.
that you're saying that you believe that you are being sexually harassed, because sexual harassment is the violation of law. Looking at somebody in a way that they don't like, that's, it's not really clear what that means.
Right. Do I need to have emotional damages if I have sexual quid pro quo? Do I have to have other damages, or is that sufficient?
I mean, quid pro quo is actionable in and of itself, but again, with any type of claim, your ability to recover damages for what you've endured is increased if you can make a correlation between what has happened to you and the impact that it's had on you. I mean, if you go to a jury and you're just like, oh yeah, that happened, but it didn't really bother me, the jury's not going to want to give you any money.
You shared a case with me. There was a woman that felt that she was being harassed by someone, and they ended up firing her.
Mm-hmm.
She ended up being successful. She won the case, but as far as damages, she lost because she was wearing suggestive clothing herself, and the jury looked at that. So just because you win a case doesn't mean that you're going to get any money. Is that correct?
Unfortunately, that's correct.
So I can win a sexual harassment case
Mm-hmm.
and not get any damages.
That's correct.
What are my damages based upon?
Well, you have typically it's two broad categories of I'm trying not to be too legal, but economic damages, which falls into like lost wages if you're terminated or demoted. Like, what is your wage loss? What's the value of your decrease in your compensation? And then you have non-economic damages, and those are damages that are based on emotions, like how humiliation, embarrassment.
Can you get that for sexual harassment?
Yes.
Humiliation, embarrassment.
Yes, you can get emotional damages. I'm terming, you can get emotional damages for sexual harassment. The form of the emotional damages is different for each person.
Right.
Everybody's not gonna have, everybody's not gonna be embarrassed. Everybody's not gonna, it's not gonna affect everybody in the same way. So how your emotional damages actually play out is according to the impact that it has on that person.
Okay, very good. And what about religious discrimination? Do people have the right to say that you have to, conform to their standards, I want you to take off your hijab? Can they tell me that?
There was a case where they did say that. I think it was, I forget what that story is, Abercrombie. And I think that they refused to hire her because she wore a hijab, and the Supreme Court said that was okay because they had a standard of appearance for their workers, and that didn't fit in with their standard. Now, you might have to edit this out because I could be wrong, but there are some circumstances where an employer can infringe upon an employee's religious rights. There are some of those circumstances.
Okay, very good. Well, listen, you know what? This has been wonderful talking to you. It's been very enlightening because a lot of times, I've learned so much during this time that I didn't know. I mean, I get people all the time. It's a hostile work environment. My boss is harassing me, but they're black or they're a woman. And so there's no protected class that is implicated. And unfortunately, as bad as it is, it's not actionable. Is that correct?
That's correct. I mean, and I get calls, and that's what I have to tell people all the time. Just because something is unfair doesn't mean it's illegal. People think because their supervisor did something wrong or that they didn't like that they can sue.
But let me
them
ask
for
this
that.
question. Remember I asked you about you said Abercrombie.
Mm-hmm.
If I work for Wayne County, can the state tell me take my hijab off?
I don't know.
Okay.
I don't know the answer to that. I do know that the Wayne County sheriffs, had and I don't know what happened with this, but I know that there was something about the beard, and that they couldn't have beards, and someone wanted an accommodation to wear a beard. And maybe I shouldn't mention Wayne County specifically, but I know that has been an issue in other departments because in some religions they don't shave their beards.
Okay.
And so how that actually plays out, played out. I'm not
So
really sure.
listen, if I've got a question about my claim, please, I can't tell you how many cases I've had that erupted in violence because of workplace discrimination, harassment. Go see a lawyer. Don't let it build up in you, and then we hear about people going to the post office and hurting other people. Why? Because they're fed up and they don't know where to go. We know where to go. And where do we go?
313-771-5600. And I do have people that I walk through their employment situation. And so, there was a lady who worked at a non-small profit, and she was going to make a complaint to her board about some things that she felt were illegal. And she was concerned about being fired. She made the decision that reporting was more important to her. She did that, and she was fired. And I sued for her, and we settled very quickly. And she ended up finding another job and moving on. But
let me ask these questions, and for our viewers, somebody's discriminated against. Can you just send what's called a demand letter and get money, or do you got to go to a jury trial and wait all that? What can you do to make me whole if there is a violation? Can you go to that employer as my lawyer and advocate for me short of going to a jury trial or a bench trial?
Of course, and that is, the consideration is always what's in the best interest for the client. And sometimes it doesn't make sense to file a lawsuit because of the time and costs involved. And so sometimes it also doesn't make sense for an employee to file an outside charge, depending on what the issue is. And so if there's a situation where I can communicate directly with the employer on behalf of that employee and get it resolved, then I'll do that. Now, sometimes it means money, sometimes it doesn't. Sometimes the employee just wants to leave and doesn't want to work there anymore. So it's, a matter of trying to negotiate a severance for that employee so that they can, leave and have some money in their pocket.
So you do that?
I do that. Yes.
Okay, so look, I can't take it anymore. You say, Vonda, look, it's not worthy of going to trial. Can you help me? Can I just get what I put in? Can I come to you? Can you help me do that?
Yes.
And you can say, we're going to put together a letter, and I'll document what I have. I got a right to sue letter, and you're able to go there and have you been successful?
I have been successful. Not always. Some employers don't respond. Some employers, like to be very very aggressive. So I do like to tell people I can never guarantee.
Absolutely not.
I guarantee.
But do you think that sometimes that's kind of splitting the baby down the middle a little bit?
Right. Yes.
And that some employers are open to that.
Yes.
My last question, in the age of Me Too, oh my goodness, okay, and what's going on, what we see going on every day, and how the Me Too movement is alive and growing. Are employers willing to settle cases that have a sexual component opposed to going all the way to trial?
Yes, they are. And that's because the employer is also looking at the cost of having to defend a lawsuit if it went to trial. They have to get lawyers. They have to pay lawyers. So they're looking at, can we save some money if we just try to resolve this up front? Can we go around our insurance company and not have to file a claim or do X, Y, and Z in order to get this resolved? So yes, that's definitely a consideration. But again, the strength of my ability to do that comes from the client and the client's documentation and credibility. Because the more credible the client is, the more documentation the client has, the easier my job becomes.
300 days is a controlling time in which I need to start writing things down if I'm experiencing it. Is that correct? You have 300 days to kind of get all this stuff together somewhat.
The time to file with the EEOC varies depending on the situation, but
the rule of thumb, maybe 300 days. Start writing stuff down. Start emailing. Start letting people know who was here, who was a witness there to help you. Is that correct?
Yes.
So if you know it, you don't have to accept it. you can stand up for yourself, and you can fight back. And it doesn't matter how big the company is. As a matter of fact, we're not even going to go into it, where there was a judgment for $16 million against Ford Motor Company for their harassment when they allowed an employer or a person in management to discriminate against an employee. It was $16 million, I believe that the verdict was. So we're not talking about like $50 or $100. We're talking about sizable money, if that can be shown. Is that correct?
Right.
And one of the things that it seemed to appear in that particular lawsuit, that he talked about damages, emotional, economic, non-economic, everything that was going on. But it was reporting, putting it all together, and presenting it to the lawyer.
And he was a longer term employee too, which is something that people, should consider if they've been there 6 months versus if they've been there.
Last question.
2 years.
That's a lawyer's always last question. Can an employer trade a 40-year-old employee in for 220s?
No, it would be illegal if you can prove that they made that decision based on age.
They get rid of me. I'm old. They turn around. I make $50,000. They end up hiring somebody that's 25 years old, and they're paying them a less, but she's doing the same job as me. Is that illegal?
Not necessarily. It depends on, you have to make the correlation between age. Now, if they're saying because of financial constraints they couldn't afford to pay you what they were paying you before, that's not age. That's,
okay.
Financial.
But if they're paying her the same amount as they're paying me, that's actually...
Well, that's more evidence that it's probably age.
Well, thanks so much for coming. And what's that number again?
313-771-5600.
Listen, I went over time. I had such a ball. It was so knowledgeable. I had so much fun learning. This is a growing area. There are not a lot of people that are very knowledgeable. And for Terry to take the time to come out and to be able to explain what needs to, what you need in order to pursue a claim, I think it was worth it. Again, your number is
313-771-5600.
If you are being discriminated against in your job based on race, sex, ethnicity, gender, weight, whatever, and you are uncomfortable with it, give them a call and let them help you out in pursuit of your claim. Thank you so much.
Thank you. Thank you for having me.